Good day, everyone. My name is Scott Reich, and this is Crime Talk. Yes, it is Sunday, and yes, today is the weekly recap of all the top stories that we brought you throughout the week, all conveniently located in one location. I hope you enjoy it. Thanks for watching, and we'll see you next time on Crime Talk. Next, this guy tried to kill a plane full of people. So as you know, off-duty pilots, if they're going back to the city in which they live, they commute for work, they can often ride in what they call the jump seat up in the cockpit. So this off-duty pilot is now accused of trying to shut off the engines on a full Alaska Airlines passenger jet on Sunday and has now been charged with 83 counts of attempted murder. Who is this guy? Joseph David Emerson. And I can guarantee you that his pilot's license is going to be, if it hasn't been so already, revoked. So Mr. Emerson faces the litany of homicide charges, along with an additional 83 counts of reckless endangerment and 1 count of endangering an aircraft, according to police records. Mr. Emerson is believed to have been seated in the jump seat beside the operating pilots. Actually, it's kind of behind them. They were on board of an Embraer 175 airplane from flying from Everett, Washington to San Francisco. Now, according to the Federal Aviation Administration, he is accused of attempting to deploy the fire suppression system before crew members managed to subdue him and remove him from the controls. So what exactly is the fire suppression system? Well, what that is on a jet airplane, if you're flying along and you suddenly get a warning light or engine fire light, you arm the fire suppression bottles and you do that and it'll immediately put out the fire in the engine. It also sucks all the air out of it, and basically the plane is going to shut the engine off. So apparently Mr. Emerson tried to do this to both engines, and had that taken place, that would have been a big problem because both engines would have been out and unable to restart, because after you deploy that suppression system, the engines basically need to be serviced or rebuilt at a very expensive amount, I might add as well. So that could have been a big problem. Now, the Alaska Airlines has stated that the flight departed Washington State about 5:23 p.m. and was diverted to Portland International Airport following a security threat. Now, the crew secured the aircraft without incident, thank goodness. And if you listen to live ATC audio, it appears to show a pilot describing the person believed to be Mr. Emerson subdued after the incident.
Okay, I'll just give you a heads up. We've got the guy that tried to shut the engines down out of the cockpit, and he doesn't sound like he's causing any issue in the back right now. I think he's subdued. Other than that, we want law enforcement as soon as we get on the ground and park.
The pilots did request that they want law enforcement as soon as they got on the ground, and they were parked. Now, Mr. Emerson was arrested by the Port Authority there in Portland, and obviously remains in custody. Yeah, you can't go around doing that, ladies and gentlemen. Airplane's dangerous. Don't go trying to shut people's engine off. You don't do that. It is Sam Bankman-Fried. That's right. The now defunct, failed founder of cryptocurrency exchange FTX is planning to testify at his criminal trial in Manhattan. Now, this is according to his lawyers. The lawyer, Mark Cohen, confirmed that Mr. Bankman-Fried's plan at a hearing with prosecutors and the judge overseeing the case, which was held on the last day of nearly a week-long break in the trial. Now, Mr. Fried is likely to testify on Thursday after federal prosecutors call their final witness in the morning. Mr. Cohen, the attorney, said, "Our client is going to be testifying." Now, Mr. Bankman-Fried is charged with orchestrating a sweeping scheme of allegedly stealing as much as $10 billion from customers from their FTX exchange accounts. Now, prosecutors allege that the mogul funneled the money into political contributions, real estate purchases, and other lavish spending on behalf of the company. Now, Mr. Bankman-Fried has obviously pled not guilty to all 7 charges of fraud, conspiracy, and money laundering. But if he is convicted, he will spend, well, what amounts to basically a life sentence, a little over 105 years. So SBF is going to have to answer the accusations that he embezzled funds from the FTX customers in order to prop up his hedge fund, Alameda Research, and buying these luxury properties and donated $100 million to political candidates. Now, remember, he launched the company in 2009 and it grew quickly, worth billions of dollars. And he recruited a lot of celebrity people like Tom Brady and Larry David to promote his FTX firm and also, hang out with a lot of politicians, including former President Bill Clinton. Now, Bankman-Fried's inner circle has turned on him and testifying against him as well, taking their own plea deals. Now, during this trial, his former top executive and ex-girlfriend, Caroline Ellison, blamed the FTX founder for corrupting her values so she could lie and steal, and got emotional when describing the cryptocurrency's final days, saying the collapse of his business resulted in a relief that he didn't have to lie anymore. Now, Ellison blamed SBF as she was intertwined romantically for several years since 2008 for creating justification so that she could do things that she now admits were wrong and illegal. Well, Miss Ellison pled guilty to fraud charges back in December when old Bankman-Fried was extradited to the United States from the Bahamas. Now, the FTX co-founder, a guy by the name of Gary Wang, also testified against Bankman-Fried, saying he committed wire, securities, and other commodities fraud as the chief technical officer at FTX after also sharing ownership in Alameda Research. He said that Bankman-Fried directed the illegal moves, and in what could be a glimpse into the defense, Mr. Bankman-Fried has written a 250-page unpublished memorandum in which he blamed his former Lieutenant Ellison for the cryptocurrency collapse. Now, he never published this, but this little memo, if you want to call it, is one of the reasons why he got his bond revoked. Anyway, it gives a little perspective on what led to the FTX collapse, or at least what he is going to claim it will be. And it's basically that if Ellison had simply followed his advice, this never would have happened. And he also claims now that she was ill-equipped for the role that he gave her and that she refused to implement these trading strategies that would have prevented the collapse. Now, of course, he was in charge and he put his girlfriend in charge, even though apparently she wasn't qualified, according to him. So he made the wrong decision, apparently. He wrote in his little memoir that she continually avoided, referring to Ellison, talking about risk management, dodging my suggestions until it was too late. Every time that I reached out with suggestions, it made her feel worse. I'm sure being her ex didn't help as well. And Bankman-Fried and Ellison, like I said, had this romantic relationship, which ended. And he claimed they wanted more intimacy and commitment and public visibility than he wanted to, and made him feel claustrophobic. So, in a show of what the defense strategy is going to be, that Alameda would still be solvent if Ellison had agreed to hedge its aggressive trading strategy, as he claims. Now, let's take this for what it is. Why I cannot wait, and I wish we could see this on TV. This is going to be one of the biggest calamities ever to take place in a courtroom. Mark my words. We don't know if old Sam Bankman-Fried is going to get his Adderall, because apparently that's what he needs to function. We'll see. I hope he doesn't, because we get to see the true person. And when you're on the witness stand, you shouldn't be basically doped up to be on your game, so to speak. Cross-examination will be the greatest truth-seeking tool ever. It is the greatest truth-seeking tool ever invented. And Sam Bankman-Fried, I think, has no idea what is coming his way. This guy thinks he is the smartest guy in the room. Now, I have represented lots of con men over the years, and Sam Bankman-Fried is nothing more than a con man. That's it. He took a legitimate idea. Yes, he took it to the next level. He was willing to bet everything because he figured he had nothing to lose. And when everything else came crumbling down, he's going to say, it's not my fault. And he does what every white-collar person does when they says there's a crime, they're accused of something, of taking somebody else's money. I just need a little more time. If they just done it my way, it would be okay. I think that this guy is going to be exposed for what he is. Yeah, he may be a smart guy. He went to, Stanford, and, his parents are really smart. But the problem with that is you can be smart, but he's just arrogant. And this guy thinks he's smarter than everybody in the room, and he's going to get up there and he thinks he can explain his way out of this. And I predict he will fail miserably. Why? Because he is just a con man. That's all he is. And it is going to be exposed, and the jury is going to convict him, I'm going to say, of all charges. Next on the docket, Lori Vallow is headed to Arizona. Governor Brad Little has signed an executive agreement to extradite Lori Vallow to Arizona on a conspiracy to commit murder charges. Now, the governor signed the 3-page document Monday, which was sent to him by the Arizona governor, Katie Hobbs, on September 13th. And as we all know, Vallow faces 2 conspiracy to commit murder charges for the death of her 4th husband, Charles Vallow, and the attempt of the life of her former nephew-in-law, Brandon Boudreaux. Now, Vallow has been incarcerated at the Pocatello Women's Correctional Center since the beginning of August after Judge Boyce sentenced her to life in prison for the murder of her children, Tylee Ryan and Joshua J.J. Vallow. She was also found guilty of conspiracy to commit murder of Tammy Daybell, the former wife of Lori's current husband, Chad Daybell. The agreement states that it is agreed that the governor of the state of Idaho and the governor of the state of Arizona, that Lori Vallow will be extradited pursuant to this agreement from the state of Idaho to Arizona for trial, and the state of Arizona may obtain custody of the said fugitive, and the said fugitive may be transferred back and forth between the state of Arizona and the state of Idaho. Arizona will pay to transport Daybell with no further formal extradition proceedings according to this agreement. So normally when somebody is extradited, it is pursuant to a governor's warrant, and usually the state that wants the person comes and picks them up, and the defendant usually winds up paying the cost. In this particular case, obviously, Ms. Vallow is remaining in custody in Idaho, and for her to go back and forth, it's basically a fancy writ to take her to Arizona, keep her during the pendency of the trial, and then when the trial is done, guess what? Ship her back to Idaho, and when she gets done serving that life sentence, then she can go serve the one in Arizona. Obviously, that's never going to happen, but you get the gist. For those of you who are not familiar with the background as it relates to Lori Vallow and the death of her husband in Arizona, well, the grand jury indicted Vallow in June of 2021 after her brother, Alex Cox, shot and killed Vallow in his Chandler, Arizona home. Cox died in December of 2019 with the medical examiner to be deemed a natural cause, just like all the other people around Lori Vallow. Natural causes. Well, a second grand jury indictment was filed in February of 2022 for conspiracy to commit the murder of Boudreaux. At the same time, he was married to Melanie Pawlowski, Vallow's niece. Police say that Cox was shot at Boudreaux and tried to kill him. If found guilty of these conspiracy charges in Arizona, Vallow could face a life sentence. And like I said, we know she's already doing life in Idaho. Kohberger. I think the cameras are going to remain, ladies and gentlemen. This is a good thing. So the district court judge, John Judge, opened Thursday's hearing on the Bryan Kohberger matter by saying that he had not made a final decision on the defense motion to ban cameras. As you may recall, the attorneys for Bryan Kohberger, he's accused of killing the 4 University of Idaho students at their rental last November, say that the cameras deprived their client of his 14th Amendment right to due process, and they allege that the media photographs have violated the judge's instruction to avoid focusing exclusively on Mr. Kohberger. The judge said in court, and I quote, "I'm not going to ban the cameras in the courtroom, but I need more control over what cameras are doing and what the media, not the media, is doing with the filming." That's according to the judge. Now, he says, quote, "I know I can only control so much, and that's why I continue to urge people to be patient and have some dignity and some restraint." That's basically saying, hey, media, play nice, focus on the rules that I've already put in place, and you'll be able to get what you want, which is cameras in the courtroom. We don't need every second focused on Bryan Kohberger. I want to see what the evidence is. Let the jury focus on how Kohberger reacts, all right? Now, the judge did note that photos and videos taken by the media are used by people on the internet. But he also said he was keen to strike a balance between the dual needs to achieve a fair trial and to preserve public access, which we've talked about this numerous times. We discussed the cases as it relates to the First Amendment, the press, and courtrooms. Yes, there needs to be a balance, and it should not be restrictive. So the judge said it's a benefit and potentially a harm, and it can tilt a case one way or the other if the media is trying the case in the media, and we don't want that because that's not based on the evidence. That's not based on the rules of the court, and it can get out of control. Prosecutors have been a little more concerned with the televising of the trial and motions hearing based upon the sensitive nature of the evidence as well as vulnerable witnesses. Now, I think the court can make reasonable accommodations for this. Do we need to see all of the photographs from the crime scene? Probably not. Do we need to see the photos from the autopsies? Probably not. We probably get the idea. It will be described in the court proceedings. We don't need to see the photographs of that. If there is legitimate concerns for a particular witness, maybe perhaps they're underage, then you maybe don't televise that particular witness's testimony, but we hear the audio. A balance can be struck whereby the people get to see what takes place. Now, there is a coalition of more than 20 media outlets that are arguing against banning cameras in the courtroom based upon the First Amendment grounds and say that recording the courtroom proceedings helps limit misinformation by the general public. Now, the attorney arguing for the broadcast groups to have the proceedings televised has said that the answer is not less sunshine, it's more. It says the public and this community will be best served by having those cameras in the courtroom, in which I totally agree. Now, at least two families of the victims in the killing oppose prohibiting cameras, and Shannon Gray, who represents the family of Kaylee Gonzalez's family, issued a statement on behalf of his clients and some members of the Zena Kernodle family. The statement reads, "Speculation is fueled by the secrecy surrounding everything that is filed and every hearing that is closed off to the media and the public. So it is vitally important that the trial be viewed publicly. It is important for the victim's family, relatives, community members, and the public that this veil of secrecy be lifted at trial. This not only ensures accountability for all of the parties involved, but also helps the public maintain its faith in the justice system." My goodness, that attorney must have been listening to Crime Talk because it sounds like we wrote it ourselves. Well, the judge said that he would issue a final ruling soon, but for now, cameras will remain. The court's final note on that was, "Please have patience, be respectful, and be decent. That's what I want," the judge said. Well, the judge also denied a request to dismiss the grand jury indictment in the case of Bryan Kohberger on the grounds that the defense had argued that there were errors made in the grand jury instructions and that the grand jury was misled as to the standard of proof required for an indictment. So Kohberger's defense attorneys argued that the standard of proof for a grand jury of beyond a reasonable doubt was made, but the grand jury in this case against Kohberger was given a lower standard required for an archaic process called a presentment, which requires a preliminary hearing. As a result, failing to properly instruct the grand jury is grounds for dismissal of the indictment, is what the defense argument was. But Judge John Judge denied the motion, saying, "Hey, I'm constrained by what I believe is settled law here in Idaho. It's not his job to make new law. It's his job to interpret the law based upon the facts in front of him." He says, quote, "This is certainly an issue that you would have to bring with a higher court, like the Supreme Court, i.e. after you lose a trial, you appeal it and your argument is preserved. That's what lawyers do." The judge even said, "I think the argument's good, but I can't go that far, at least not today." The judge also noted that he would issue a written order soon as well. All right,